Moorish Empire. Ancient Moorish Empire. United States for America. Moorish nationall Republic Federal Government. Societas Republicae al Moroccanos. Moorish Divine Ande Nationall Movementi of the year the Northwest to Mexim plus Northwest Africa plus North America plus the North Gate. All adjoining islands. Temple of the Moon Ande Sun. The true Ande de jure natural peoples plus heirs of the land. ISLAM. Universal Sovereign Original Indigenous Ancient Natural Divine. Quo Warranto Mandamus Restitutio Writ of Execution. Ancient, Tom Moori Land, Maryland Territory. Mac plus cause 000000120. All rise and stand and remain standing into perpetuity. This is a sovereign living ancient Article 3 Moroccan National al Moroccan Universal Court Action. I am the Sovereign Chief Justice having living born appellation Byron Calvin Rodgers, in capitis diminutio nolo, in red ink, in propria persona sui juris, in proprio solo, ande in proprio heredes. My free chosen nationall appellation is Byron Zahar Bey, in capitis diminutio nolo, in red ink, in propria persona sui juris, in proprio solo, ande in proprio heredes. All Moors are the original indigenous sovereign ancient al-Moroccan nationals ascendants of the great pharaohs of Kemet and of the ancient Moabites, Canaanites, Shemites, Israelites, Hammatites, Cushites, and Hittites. Our full faith and trust, our allegiance, our credit, and our energy are hereby vested in ourselves, for we are the people who are the original indigenous natural divine sovereign ancient empire state for Morocco Ande. The de jure Moroccan National Republic Federal Government, Washington District for Columbia, the Universal Moorish American Consulate, Ande the Earthwide Article 3 Moorish American Consular Court. Today, we are executing and exercising the law by our sovereign capacity, which is the original indigenous natural divine sovereign ancient Article 3 living United States District for Columbia Court, and we are the sovereign fiduciaries, secured creditors, executors, trustee, ministers, possessors, and beneficiaries in this cause of action. We are peace. We are one nation, one state, one empire, and one God. We hereby accept our sovereign ascension, issue a universal creditor's bill for possession, 9/10 of the law, and custody, 1/10 of the law, against all judgment debtors, and exercise all sovereign rights at this time and at all points in time nunc pro tunc. North America, United States for America, Maryland. Land Territory ande lokatione. Maryland Constitution. Maryland Constitution, November 11, 1776, restated 2024 October 25. We the sovereign original indigenous Moorish American people restate our Maryland Territory Constitution on this day, 2020+4 October 25, Friday, for all people of the land, all foreign subjects, citizen and persons within Maryland Territory subject to our dominions. Rights Declaration. We the people are the original indigenous sovereign fiduciaries, secured creditors, executors, trustee, ministers, possessors, and beneficiaries in this cause of the action. We the people of Maryland Territory, grateful to the Almighty Creator for our sovereign authority, civil and religious liberty, and taking into our serious use consideration the best means of establishing a good constitution in our land state for the sure foundation and more permanente security thereof declare and affirm. Article 1. That all government right originates from the people, subject to our authority, and instrumentated solely for the good of the whole, and we have, at all times, the inalienable right to alter, reform or abolish any form of government in such manner as we deem expedient. Art. 2. The Constitution for the United States for America, and the laws of the land, made, or which shall be made, in alignment thereof, and all treaties made, or which shall be made, under our authority for the United States, are, and shall be the supreme law of the land and for the state, and the judges of this state, and all the foreign subjects of this state, are, and shall be bound thereby, anything in the Constitution or law of this state to the contrary notwithstanding. Art. 3. The powers not delegated to the United States by our Constitution thereof, nor prohibited by it to the States, are reserved to the State respectively, and to the people thereof. Art. For, that the people of this state have the sole and exclusive right of regulating the internal government and police thereof, as a free, sovereign people and independent state. Art. 5a. 1. That the sovereign people of Maryland are entitled to the ancient supreme law of the land, and treaties made, the trial by jury, according to the course of the law, and to the benefit of such of the American original indigenous peoples' rights and laws exist in and treaties prior to the 4th day of July, 1776, that the foreign common inhabitants and their persons are subjects of and to the sovereign people of Maryland and are entitled to the common law of England and which, by experience, have been found applicable to their local and other circumstances, and have been introduced, used and practiced by the courts of law and equity, and also of all acts of the Assembly in force on the 1st day of June, 1860. 7. Except such as may have since expired, or may be inconsistent with the provisions of this Constitution, subject, nevertheless, to the revision of and the amendment or repeal by the legislature of the state, and the people of Maryland and are also entitled to all property derived to them from, or by the allodium Maryland Charter. 2. Legislation may be enacted to the right to trial by jury in civil proceedings to those proceedings in which the amount in controversy exceeds $25,000. All local at land currencies Moorish sovereign delarium gold receipts and in lawful money gold, silver shall be the payment for all at land transactions and exchanges as stated by laws published. B. The parties to any civil and or criminal proceeding in which the right to a jury trial is preserved are entitled to a trial by jury of at least 6 jurors. C. That notwithstanding the common law of England as pertinent to subjects and persons, no thing in this Constitution prohibits trial by jury of less than 12 jurors in any civil proceeding in which the right to a jury trial is preserved. Art. 6. That all persons invested with the legislative or executive powers of the subject government are the trustees of the public, and, as such, accountable for their conduct. Wherefore, whenever the ends of the government are perverted, and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may, and of right ought, to reform the old, or establish a new government, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish and destructive of the good and happines of man and mankind. Art. 7. That the right of the sovereign people to participate in the legislature is the best security of liberty and the foundation of all free government, subject or sovereign. For this purpose, elections ought to be free and frequent, and every citizen subject having the qualifications prescribed by the Constitution, have the right of suffrage. Art. 8. That the legislative, executive and judicial powers of the subject government ought to be forever separate and distinct from each other, and no person exercising the functions of one of said department shall assume or discharge the duties of any other. Art. 9. That no power of suspending laws or the execution of laws, unless by, or derived from the sovereign people, ought to be exercised, or allowed. Art. 10. That freedom of speech and debate, or proceedings in the legislature, ought not to be impeached in any court of judicature. Art. 11. That Annapolis be the place of meeting of the legislature, and the legislature ought not to be convened, or held at any other place but from evident necessity. Art. 12. That for redress of grievances, and for amending, strengthening and preserving the laws, the legislature ought to be frequently convened. Art. 13. That every man hath a right to petition the legislature for the redress of grievances in a peaceable and orderly manner. Art. 14. That no charge, tax, burthen, or fees ought to be rated or levied, under any pretense, without the consent of the people and or legislature, aid and assistance shall be given. Art. 15. that the levying of taxes by the poll is grievous and oppressive, and ought to be prohibited, that sovereign people are not taxed or to be assessed for tax in the support of the subject government, that the General Assembly shall, by uniform rules, provide for the separate assessment, classification and subclassification of land, improvements on land and personal property, as it may deem proper, and all taxes thereafter provided to be levied by the state for the support of the general state government, and by the counties and by the city for Baltimore for their respective purposes, shall be uniform within each class or subclass of land, improvements on land and personal property which the respective taxing powers may have directed to be subjected to the tax levy. Yet fines, duties or taxes may properly and justly be imposed, or laid upon the foreign subjects within political view for the good government and benefit of the community. Art. 16. That sanguinary laws ought to be avoided as far as it is consistent with the safety of the state, and no law to inflict cruel and unusual pains and penalties ought to be made in any case, or at any time, hereafter. Art. 17. That retrospective laws, punishing acts committed before the existence of such laws, and by them only declared criminal or oppressive, unjust and incompatible with liberty, wherefore, no ex post facto law ought to be made, nor any retrospective oath or restriction be imposed, or required. Art. 18. That no law to add in particular persons of treason or felony, ought to be made in any case, or at any time, hereafter. Art. 19. That every living man, for any injury done to him in his person or property, ought to have remedy by the course of the law of the land, and he ought to have justice and right, freely without sale, fully without any denial, and speedily without delay, according to the law of the land. Art. 20. That the trial of facts, where they arise, is one of the greatest securities of the lives, liberties and estate of the people. Art. 21. That in all criminal prosecutions, every man hath a right to be informed of the accusation against him, to have a copy of the indictment, or charge, in due time, to process, to prepare for his defense, to be allowed counsel, to be confronted with the witnesses against him, to have process for his witnesses, to examine the witnesses for and against him on oath, and to a speedy trial by an impartial jury, without whose unanimous consent he ought not to be found guilty. Art. 22. That no man ought to be compelled to give evidence against himself in a criminal case. Art. 23. In the trial of all criminal cases, the jury shall be the judges of law, as well as of fact, except that the court may pass upon the sufficiency of the evidence to sustain a conviction. The right of trial by jury of all issues of fact in civil proceedings in the several subject courts of law in this state, where the amount in controversy exceeds the sum of $15,000, shall be inviolably preserved. Art. 24. That no man ought to be taken or imprisoned or decised of his freehold, liberties, or privileges, or outlawed, or exiled, or, in any manner, destroyed, or deprived of his life, liberty, or property, but by the judgment of his peers, or by the law of the land. Art. 25. That excessive bail ought not to be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted, by the courts on law. Art. 26. That all warrants, without oath or affirmation, to search suspected places, or to seize any person or property, are grievous and oppressive, and all general warrants to search suspected places, or to apprehend suspected persons, without naming or describing the place, or the person in special, are illegal, and ought not to be granted. Art. 27. That no conviction shall work corruption of blood or forfeiture of estate. Art. 28. That a well-regulated militia is the proper and natural defense of a free government. Art. 29. That standing armies are dangerous to liberty, and ought not to be raised, or kept up, without the consent of the legislature. Art. 30. That in all cases, and at all times, the military ought to be under strict subordination to, and control of the civil power. Art. 31. That no soldier shall, in time of peace, be quartered in any house, without the consent of the owner, nor in time of war, except in the manner prescribed by law. Art. 32. That no person except regular soldiers, marines, and mariners in the service of the state, or militia, when in actual service, ought, in any case, to be subject to, or punishable by martial law. Art. 33. That the independency and the uprightness of the judges are essential to the impartial administration of the justice, and a great security to the rights and the liberties of the people. Wherefore, the judges shall not be removed, except in the manner, and for the causes provided in this Constitution. No judge shall hold any youth or office, civil, or military or political trust, or employment of any kind, whatsoever, under the Constitution or laws of the state, or of the United States, or any of them, except that a judge may be a member of a reserve component of the armed forces of the United States, or a member of the militia of the United States or this state, or receive fees, or perquisites of any kind, for the discharge of his official duties. Art. 34. That a long continuance in the executive departments of power or trust is dangerous to liberty. A rotation, therefore, in those departments is one of the best securities of permanente freedom. Art. 35. That no person shall hold, at the same time, more than one office of profit, created by the Constitution or laws of the state, nor shall any person in public trust receive any present from any foreign prince or state, or from the United States, or any of them, without the approbation of this state. The position of notary public shall not be considered an office of profit within the meaning of this article. Non-elected membership in the militia of this state, a law enforcement agency, a fire department or agency, or a rescue squad shall not be considered an office of profit within the meaning of this article. Nor shall any remuneration received as a consequence of membership in a reserve component of the armed forces of the United States or of membership in the militia of the United States or of this state be considered a present within the meaning of this article. Art. 36. That as it is the duty of every man to worship God, by his own vine and fig tree, in such manner as he thinks most acceptable to him, all persons are equally entitled to protection in their religious liberty. Wherefore, no people or person ought by any law to be molested in his person or estate, on account of his religious persuasion, or profession, or for his religious practice, unless, under the color of religione, he shall disturb the good order, peace, or safety of the state, or shall infringe the laws of morality, or injure youthers in their natural, civil, or religious rights. Nor ought any person to be compelled to frequent, or maintain, or contribute, unless on contract, to maintain any place of worship, or any ministry, nor shall any person otherwise competent be deemed incompetent as a witness, or juror, or on account of his religious belief, provided he believes in the existence of a divine creator or God, and that under his dispensation such person will be held morally accountable for his acts, and he be rewarded or punished therefore either in this world or in the world to come. No thing shall prohibit or require thee make in reference to belief in, reliance upon, or invoking the aid of God or a supreme being in any governmental or public documenti, proceeding, activity, ceremony, school, institution, or place. No thing in this article shall constitute an establishment of religione. Art. 37. That no religious test ought ever to be required as a qualification for any office of profit or trust in this land, other than a declaration of belief in the existence of God, nor shall the legislature prescribe any other oath of office than the oath prescribed by this Constitution. Art. 38. All local at land currencies are Moorish sovereign delarium, Moorish sovereign delorium gold receipts and lawful money gold. Silers shall be the payment for all at land transactions and exchanges as stated by laws published. Art. 39. That the manner of administering an oath or affirmation to any people ought to be such as those of the religious persuasion, profession, or denomination, of which he is a member, generally esteem the most effectual confirmation by the attestation of the divine Creator. Art. 40. That the liberty of the press ought to be inviolably preserved. That every citizen of the state ought to be allowed to speak, write and publish his sentiments on all subjects, being responsible for the abuse of that privilege. Art. 41. That monopolies are odious, contrary to the spirit of a free government and the principles of commerce, and ought not to be suffered. Art. 42. That no title of nobility or hereditary honors ought to be granted in this state. Art. 43. That the legislator ought to encourage the diffusion of knowledge and virtue, the extension of a judicious system of general education, the promotion of literature, the arts, sciences, agriculture, commerce and manufactures, and the general amelioration of the condition of the people. The legislature may provide that land actively devoted to farm or agricultural use shall be assessed on the basis of such use and shall not be assessed as if subdivided. Art. 44. That the provisions of the Constitution for the United States, and for this state, apply, as well in time of war, as in time of peace, and any departure therefrom, or violation thereof, by plea of necessity, or any other plea, is subversive of good government, and tends to anarchy and despotism. Art. 45. This enumeration of rights shall not be construed to impair or deny other rights retained by the sovereign original indigenous people. Art. 46. Equality of rights shall not be abridged or denied. Art. 47. A victim of crime shall be treated by agents of the state with dignity, respect, and sensitivity during all phases of the criminal justice process. B. In a case originating by indictment or information filed in a circuit court, a victim of crime shall have the right to be informed of the rights established in this article and, upon request and if practicable, to be notified of to attend, and to be heard at a criminal justice proceeding, as these rights are implemented and the terms crime, criminal justice proceeding, and victim are specified by law. C. Nothing in this article permits any civil cause of action for monetary damages for violation of any of its provisions or authorizes a victim of crime to take any action to stay a criminal justice proceeding. All ancient sovereign original indigenous Moorish nationals justices /viziers /ministers in propria persona sui juris in proprio solo and in proprio heredes autographs affirm for this action and all sovereign United States for America government documents are on the public record at the ancient Morocco Moorish Empire Americas. North Amexum /Northwest Africa /South Amexum /Northgate /adjoining Islams. Chronos time immemorial into perpetuity 22 Rabi al-Thani 1446. October 25 Tishrin al-Al 2024 date, 2024 Greco-Roman Friday October 25. Ego sum. I am. In capitis diminutio nolo, in red ink, in pro In capitis diminutio nolo, in red ink, in propria persona sui juris in proprio solo in proprio heredes. Notice to agent is notice to principal. Notice to principal is notice to agent. Empire State of Morocco. Moorish Nationall Republic Federal Government. Moorish America Consulate. Care of 613 East Chase Street. Baltimore, Maryland Territory. Ancient, Muuri land. Universal Nationall Code, 8 LGD 4T PJHCKB. Latitude